There you go. So, welcome everyone to our fourth installment of these training sessions, information sessions on property management for owners and managers. Today, we're going to be talking about the duties and obligations during the tenancy. We've been talking about what needs to go in your lease agreement. We've talked about what kind of notices you give and how to give them if you're going to be terminating a lease. Now we're going to talk about today things that you're required to do, communications, how you do it, managing the property, dealing with tenant issues, roommate issues, that sort of thing. So we're going to um, go over again. This is an overview of the basics. There's a lot more to each of these topics, of course. And it's important also that you stay up to date on your obligations because there are new ones added and changed almost every year in California. So we are recording these presentations. They're going to be available after today's session. The other three, I believe, are already been uploaded to the rental resources page on the City of Davis website. This one and copies of these slides will be there shortly. So you'll be able to go back and review any of this information. Also, at the end of the presentation today, I think I have my contact information on there. If any of you have follow-up questions or need information or assistance beyond what we're talking about today. There will be some time for Q&A at the end. So if everyone can please just stay muted and hang on to your questions until we get to the end. I would say, because this is going to be recorded and then posted publicly, if you do want to ask a question, kind of keep it as a general question so as not to give out any property addresses or individuals' names that may be associated with any of these situations that you will be asking about. So we'll get started with those ground rules here. If I can advance the slide, here we go. Yes, I'm Chad Carlock again. This will be my 30th year practicing law. I am a double alum of UC Davis. Lived in all sorts of different living arrangements over the years in Davis and in Woodland since I came here for undergrad. And I am associated both with the Davis Chamber of Commerce, where I'm the past chair, and also an officer for the Yolo County Bar Association, and have served as president twice and may end up back there again. And as I said, this is my contact information here. Website, emails, usually the most efficient way to reach me, but certainly you can reach me by phone as well. My office is here in downtown Davis as well. So we're going to be talking about a lot of different subjects today, which means unfortunately we can't go into, as I said, a whole lot of detail on all of them, but I want to give you kind of the basic ground rules and an overview, issues to be thinking of, and some tools to have in your back pocket when and if any of these situations arise in dealing with properties that you own or manage. We're going to talk about the how you solicit and choose tenants, do's and don'ts. Uh, Questions to ask, questions to avoid, that kind of thing. How you do the screening process, and make sure that you are selecting applicants in compliance with all of your legal obligations, including fair housing obligations and processing, application fees, all those sorts of things. What it means for the property owner to have a duty to provide habitable premises. We'll talk about what those are. There's actually been a couple of tweaks to that recently. The law has changed and expanded what the owner is required to provide in order for a premises to be considered habitable. So we'll go over that. Disability accommodations, which is could be an entire presentation all to itself as well. What they are, how to process them, what you are and aren't required to do. That also includes not just physical modifications, but also either service animals, emotional support animals, all sorts of issues that arise in terms of considering and responding to requests for accommodations. Dealing with illegal conduct in your premises, drug activity, firearms activity, criminal activity, what your duties are and are not in terms of safety and security measures, what you're obligated to provide, and what you are not obligated to provide, which again depends on what you put in your lease agreement. So we'll talk about that. We'll talk about what the landlord does and does not need to do in dealing with roommate disputes. Davis being a college town, there are a lot of folks who sort of get mixed and matched into various housing situations. And so they often end up, if they can't resolve disputes between themselves, coming to the landlord or the property manager to try to assist them or solve the problem for them. So we'll talk about how to handle those sorts of things. Um, Conduct by your tenants that does not arise to illegal conduct, but still is an issue. Things like noise and nuisance, um, damage to the property, how you on a day-to-day basis deal with those sorts of issues. Related to roommate issues and disputes, sometimes is subleasing and assignments. We'll talk about what the difference between those two is and what it means for you as an owner. And then finally, just sort of a few extra things that I wanted to mention uh, that are related to these topics that you need to kind of keep in mind or be aware of going forward. So I want to start with the process of screening and choosing tenants. There have been some legal changes over the last few years to that have kind of narrowed down and put some more constraints on the processes that you're supposed to use in order to select new tenants. Um, if you are going to charge an application fee or a screening fee or whatever you want to call it, there is a cap set by law on how much you can charge for that fee. It either needs to be the statutory formula, which is a certain number of dollars plus the CPI increase per year. They did this a few years ago, so it's creeped up now. So it's your actual cost or the statutory formula, whichever is lower. Now, your actual cost would be things like that you have to pay for in terms of actually obtaining credit reports, for example, or running background checks, any of those sorts of things. If you do that as part of your process, you can build those costs into your screening fee. So you're reimbursed for that, as long as the total of that is not over the maximum that is set by the statute, because you have to use the lower of the two standards. Um, and it varies from place to place in California because the CPI calculation is different in different states. There's a state website that you can go to find out what that is. Um, Usually, if you have actual costs, that's probably going to be lower. So you want to go with that. But just to give you an idea of what the formula sets right now, as of this year, the last time the numbers came out, it's approximately $62. So if you have, something like $100 screening fee that you're charging everyone, then that probably runs afoul of these new requirements. It's important that if you're going to, as part of your screening procedures, if you run credit reports, if you get criminal backgrounds check, if you do a court records check to see if the prospective tenants had previously been evicted elsewhere. Before you do any of those, you need to get the written consent of your applicant, which means you probably need to include some notifications and some check boxes on your application form, if you have one, asking them to give you that consent. If they don't give you that consent, you cannot run the report without their consent. It is legitimate for you to use their refusal to consent as a factor. But because you don't know what that report would say if you run it, you got to kind of be careful there. You wouldn't put too much weight in it. I certainly wouldn't recommend, disqualifying somebody solely for the reason that they refuse to consent. That could be a part of the big picture, but probably shouldn't be black and white criteria that you use. You certainly have the ability to verify their income and verify their rental history. Again, you need to get their consent to get that information for various reasons that you are all probably aware of if you're as owners and managers. Previous landlords are somewhat skittish about how much information they will give about previous tenants because they don't want to be in trouble with you if you don't like the information that they gave you. And on the flip side, if they give you a negative referral, the tenant can come back to them and cause trouble with them. So, verifying that stuff can be difficult from the landlord side. sometimes, certainly. Okay, let's go back to where we were. And then certainly the best practice and the best way to avoid claims by an applicant of a discriminatory or an inappropriate denial of housing would be to have written screening criteria. Here's what we're looking for. Here's what our standards are. We need a credit of this. We need an income of this that we can verify, and then follow those rules. They don't have to be, really voluminous, but it's best to have them in writing and make sure that as best you can. Obviously, all applicants are different, but as best you can, you want to consistently apply and follow your screening criteria when you're selecting um, prospective tenants. Uh, in employment, California has what's called ban the box legislation, which means that you cannot, as a screening criteria for employment, ask about uh, criminal history and especially not ask about certain criminal offenses. Similarly, here, if you have criteria, certainly it's legitimate to say if you have a criminal history, uh, we are going to factor that into our decision of whether or not to rent to you. But it shouldn't be, again, not a black and white rule. It depends on, what the offense was, what the nature of it was, how old it was. All those sorts of things are things that should be considered in the big picture when selecting tenants. And then finally, you must also, obviously, of course, your criteria and your advertising should certainly say that you're a uh, equal opportunity, fair housing, compliant property. And the requirements regarding protected characteristics means you cannot refuse to rent someone solely on the basis of having one of those protected, being in or a member of or identified from the outside as having a protected characteristic. So that's, gender, marital status, family size, sexual orientation, all those sorts of things. And if you are denying housing based solely on one of those factors, or if the tenant believes you are, that can actually get you into trouble with uh, the Department of Fair Employment and Housing here in California and the federal folks as well. There are, for public subsidized housing, there are additional, rules that they need to follow that are set down by the feds. And in terms of complying with subsidized housing requirements, those also get factored into your rules and regulations that you have for your tenants, which we'll talk about shortly. Um, again, in the process of screening, one of the things that you need to do is make all your required disclosures to your prospective tenants. There are several legal requirements of circumstances if they are present in the housing at the time that the person is applying and you'll be renting to them. You need to disclose. If there is any known asbestos, toxic mold, bed bugs, or meth or fentanyl contamination in the unit that you are renting, they are entitled to know that. Obviously, you're going to want to remediate that as best you can before it starts. Uh, Ideally, you'd want to completely get rid of that, but if there is contamination there or has been in the last several years and it was remediated, the prospective tenants need to be informed of that. The next few things here are publications, informational publications on these topics that you are required to give to your tenants at the start of the lease. Either as a part of the lease, if you make it one big packet, or as an addendum to the lease, or at least at the same time as the lease. And then ideally, you also want to have them either as part of the lease or on the addendum where you're giving them this information, have them acknowledge in writing that they have received all of this information that you're required to give them. Uh, that is a lead-based paints publication called Protect Your Family from Lead in Your Home. There are PDFs of all of these available out there on the internet, and I believe most of these are on the City of Davis Rental Resources website, so that's a good place to start to get all of these. Um, Some of them haven't been updated in a while, but they're still out there. And you're required by law to provide these to your tenants. Information on dampness and mold centers in California. That's a publication by the California Department of Public Housing. That's what that acronym is. Um, Information on bed bug identification, prevention, and reporting procedures. That is also another handout, PDF document that you need to include in the information you give to the tenants at or before the beginning of the lease. And then the City of Davis has its own specific publication. In addition to the first three are all right above this are all state requirements and federal requirements. In fact, for the lead-based paints one, the City of Davis's unique publication is Renters' Rights and Responsibilities. That is, I believe, a one-pager, it might be a two-pager. That's on the city's website. There's also a 2 or 3 page PDF that the city has published on how to use all the different waste sorting receptacles that the organic waste, recycling, and landfill waste containers, which you are obligated as landlord to provide. So you notify the tenants about how to use those properly and what goes in what bin. If there has been a death on the property by any cause other than HIV/AIDS, that was a carve out from the law, any other death on property within the last 3 years, any cause, has to be notified to the prospective tenant. They can then make a choice of whether they still want to apply or not based on all of this information that you're giving them. If there is a sharing or allocation of costs between landlord and tenant for utilities, then it needs to be specifically disclosed what that allocation is to the tenants. Best to do it in writing. Usually that's done in the lease in advance of the start of the tenancy. So that's another piece of information you have to give them. So we'll talk now about what habitable premises are. One of the most popular defenses in eviction lawsuits is that the landlord had breached their obligation to provide habitable premises. So the law defines exactly what that is. In order for premises to be considered habitable, it has to meet all of these conditions. So if any one of them is not present, the dwelling is considered not habitable. And we'll talk about what that means in a second after we go through the definition. So the roof and the exterior walls have to be structurally sound and weatherproof, so no leaks, including unbroken windows and doors. So a broken window renders the premises uninhabitable. If the window is broken by the tenant, you can charge them for the repair, but you still need to do the repair as soon as possible to make sure that you restore the premises to their habitable position. Plumbing and gas systems in good working order, hot and cold running water. And of course, some of these only the tenants will know if they are not working. So it's best to include in a lease specific requests and requirements that the tenants notify you promptly if there are any problems in any of these areas so you can address them. The heating system has to be in good working order. Because California has so many different climates, air conditioning is not listed in the habitability requirement. Only the heating system must be in good working order. Although around here, there's a good portion of the year when non-working AC is a pretty serious problem. So I wouldn't say don't address that if it comes up, but it is not listed in the requirements for a habitable premises. Electrical lighting has to be in good working order. The building and the grounds clean, sanitary, and free from rubbish at the time of lease commencement. So it has to be in good shape when they move in. Then the responsibility shifts to the tenant to maintain it in that clean, sanitary, free from rubbish condition. And we can talk a little bit later about what happens if they don't. There have to be adequate and appropriate waste receptacles as of lease commencement. I was just talking about that a minute ago. Here in Davis with Recology, that's the 3 different types of receptacles that are available and accessible for your tenants. All floors, stairways, and railings have to be in good repair. There was some legislation a few years ago after a couple of serious outdoor deck collapses that require owners of certain properties, most commercial properties, and a lot of the multi-unit things have to get inspections on a regular basis of any exterior decks or elevated platforms, anything like that that could be accessible to the tenants to make sure that they're inspected and safe. Um, so the new requirements, the new additions to the list of habitable requirements, starting this year, is that there has to be a functional stove in good working order in order to prepare food. Most folks provided that beforehand ahead of time, before this requirement, but now it's specifically a requirement. And then the second one is a refrigerator in good working order, which has been sort of in the past was sort of hit and miss. Sometimes a unit would be rented without a refrigerator. Sometimes it would be included. So you can still agree in the lease that your tenant will provide their own refrigerator, but it has to be done in writing. And of course, you both have to agree. So if there's not agreement in the lease, then the landlord would need to be required to provide a refrigerator in good working order. So those are all uh, the boxes that have to be checked in order to maintain premises as habitable. If there's something that's reported to you during the term of a lease that affects any of these, it's extra important to address it as quickly as possible and as completely as possible. Because if you don't, there are substantial negative consequences for the landlords, including withholding of rent. Oftentimes, either in an eviction proceeding or any other, unpaid rent situation, it will be a defense to the payment of rent that the premises are not habitable. And if the court agrees and finds that they were not in fact habitable, then you are not allowed to charge them any rent for the time period in which it was not habitable. Um, if the landlord does not timely act to make repairs after it was reported by the tenants can have the repair done themselves and deduct the cost of that repair from their rent. There are some stipulations about when you can do that and how often you can do that, and the notice that you have to give to the landlord. But that may be a phrase that you have run across before, or that you has been, raised by a tenant in terms of an issue. And that is a legal right that they have. They have to give you a reasonable time in order to make the repair. But if you don't, they can deduct that cost from their rent. You can be sued by your tenants for failure to provide habitable premises. That's something you're legally obligated to do and contractually obligated to do in your lease with them. Um, there are situations where the tenant would be permitted to break the lease early without penalty. Normally, they'd be held to their rent obligations through the end of the lease, but if the place is not habitable, they can, under certain conditions, cancel the lease. You could be subject to an enforcement action if you've got uninhabitable premises, and the public health gets involved, for example, or something like that. There could be administrative fines issued by local jurisdictions or housing inspectors, that sort of thing. And then if there are injuries to the tenants or emotional distress or disruption because they can't live there, they've had to go somewhere else because it wasn't safe, and they incurred costs, for example, you could potentially be responsible for those costs. So there are lots of reasons. If there are any reports or complaints of any issues addressing the issues of habitability, that you need to be, on top of it as quickly as possible and respond as completely as possible to restore it back to habitable condition. Entering the property during the term of the lease, um, it a lot of times people often think, as the landlord, you can, as long as I give notice, then I can go because it's my property. I got to go check it out, make sure it's safe. I'm not sure what I'm not sure what the tenants are doing. I suspect they have a unpermitted dog there, or they're running a business or something. So I'm going to go check it out. That's not usually allowed. The civil code specifically has a list, and it's an exhaustive list, so it's not a, including, these things, but these are the only permitted reasons under the law to enter uh, a tenant's property during the term of the lease. If there's an emergency, obviously, if you are entering to make needed or agreed upon repairs, alterations, or improvements. So if there is, for example, a habitability issue or that the heater's not working or whatever, you can enter for that purpose. To supply necessary or agreed services. So that can be things like, yard service or pest service and that sort of thing. You and your agents can enter to do those sorts of things. If you're the landlord and you own the lawnmower and they don't, you go over there a couple of weeks and mow the lawn. Uh, that is something that you would have to you can enter for. You have to provide the required notice, which we'll talk about in a second, for any of these reasons if you're going to be entering. To show the premises to prospective purchasers, tenants, or contractors. Some work needs to be done. You can bring, you're thinking about selling the property and taking it off the market. You want to show it to potential renters from next time. That's also a permissible reason to enter. To make a pre-move out inspection. So that is something that the tenants can request within 2 weeks before the end of the lease. They can ask you to do a pre-move out inspection and identify for them anything that would need to be repaired or cleaned in order to avoid security deposit charges at move out. You can enter to do that. If there is a court order to enter for whatever reason, to inspect balconies, stairways, and other elevated structures. I mentioned that earlier. That's one of the things that you're now required to do. And obviously, you and an engineer would need to enter to do that. Tenant has abandoned the premises. This can be tricky because sometimes you think the tenant has abandoned the premises, so you enter and there they are. And you have hopefully given notice that you're going to enter. If you didn't, because you thought they had abandoned the premises, and you enter and they are there, then potentially that could be a violation of their rights. Because in the contract with them, your lease, you are promising to give them quiet enjoyment of the property, which means they have the basically exclusive right to use the property and not be disturbed in their use of the property unless you meet one of these conditions and unless you give the required notice in advance of entry. So prior to entering for one of those reasons, the landlord's required to give reasonable notice of their intent to enter in writing. The law says at least 24 hours notice is presumed to be reasonable. That doesn't mean it's automatically reasonable. It just means it's presumed to be reasonable. And as best practice, of course, the more notice you can give, the better. One of the things that I usually recommend folks do in the notice is say, I'm planning to enter, next Tuesday at 10 o'clock to check the batteries and the smoke alarms, for example. And then in that notice, if this time does not work for you or whatever reason you want to reschedule, contact me. Unless it's an emergency, there's no reason not to work with them on the timing. So that's usually a good idea just to maintain, positive relationship. The notice needs to be either personally delivered to the tenant, left with someone else at the property if the tenant's not there, or generally left at the usual entry door. It says, posted on the premises, or left at the usual entry door. If you leave it there at the usual entry door, that's where they're most likely to actually see it. Obviously, you want to make sure that they see it so that you can avoid any disputes after the fact of, oh, well, I left notice, but the note I put the notice, on the side of the driveway, and they didn't see it, and then there you are at the house, and you're having a dispute or an issue that you didn't need to have. The landlord and tenant can agree orally for entry to make repairs or provide services. So a sort of exception to the notice of entry requirement is if you show up, still best to give notice, but if you show up and the tenant is there and they give consent, then you can enter. Um, that can also get tricky because if you have multiple roommates, some of which maybe aren't home, one of the roommates gives consent, so you've made a regular entry with consent, but you did something, you fixed something, you opened something, and one of the other tenants who was not home, who didn't want you there, or didn't want to consent, could cause problems with that co-tenant or with you. So again, it's best to give as much notice as possible and make sure you notify all the tenants as best you can. If there's an emergency, as I said, these are the exceptions. If there's an emergency, the place is on fire, obviously you can go in once the fire department's there, if necessary, to deal with what, if there's a gas leak, you can enter to turn off the gas, that sort of thing. If the tenant is present and consents, we just talked about that, or when the tenant has abandoned or surrendered the unit. Again, still best to post a notice before you enter just to make sure that they have actually abandoned or surrendered the unit. One of the reasons you might want to enter is to do an inspection to find out whether they have abandoned or surrendered the unit. Now, that is not listed on the list of permissible reasons to enter. So if you think someone has abandoned the property, you might want to give notice that you are making a repair, an alteration. You're inspecting the condition of, the fire extinguishers under the sink, or the carbon monoxide smoke detectors, whatever, and that gives you the ability to enter. Okay, disability accommodations. In general, there's not an affirmative duty for you to offer a reasonable accommodation to someone who you believe has a disability, unless they request those accommodations. You're under a legal obligation to make your premises generally, accessible. If you're not a public accommodation, like a single family home and stuff, then whether and how much and when the Americans with Disabilities Act applies to you and how far you have to go in terms of making the premises acceptable or accessible in terms of things like ramps, etc., depends on the circumstances. So that's a sidebar we won't talk about today. But if you have a question about that, it's certainly something you should consult with an attorney or an expert on what your ADA obligations are. If someone makes an accommodation request to you, it needs to be as concrete as possible. They need to explain what the accommodation they are requesting. Best to acknowledge that request as soon as possible. You want to document this whole process as best you can. Your obligation as the owner or manager is to engage in an interactive process to understand the needs that are underlying the request for the accommodation, discuss maybe any potential alternatives. If there's something that they are asking for that for whatever reason you can't provide, or would be too expensive to provide, for example, is there another way that we can still meet this need without, making that accommodation, but maybe a different accommodation that you propose as part of that interactive process? A tricky part of this, because you're supposed to be interacting with them, you have to understand their needs, is that the nature of the disability, the diagnosis of that sort of thing is not supposed to be a part of the interactive process. You can get verification from a medical provider, a treating physician, a psychiatrist, whatever, of verifying that there is a disability-related need, but that's different than asking for the medical provider to document what is your disability. That's a no-no question. The document, and sometimes either the individual does not understand that, or even their treating physician doesn't understand that, and they give you information that is more than you asked for. That's not your fault. If you have that information, you can certainly factor that into your decision making and into that process. Obviously the individual can consent to provide you with diagnostic information and that sort of thing. If they authorize their medical provider to do that, they can. But generally, in terms of how much documentation do they have to give me, the basic answer is that they don't have to give you a documentation of what their diagnosis is, what the disability is, but rather that there is a need for an accommodation that is the result of their disability, whatever that disability might be. Um, as the landlord responding to a request, you're not required to make any accommodation that imposes an undue burden. And so that, of course, sounds like a lawyer word with lots of wiggle room in it, and it is. The justification for that and the rationale behind that is that what exactly is an undue burden depends on a lot of factors that can't really be determined ahead of time. Um, what's the nature of the need? What's the nature of the request? How much would it cost to accommodate that request versus the alternatives? Um, what's the, is this a single family home with a mom and pop owner who, are running this place and this one only place? Or is this a, nationwide chain of apartment complexes that might have more resources and be able to accommodate a request more easily? And again, as I said earlier, good to have document in case there's a dispute later on, and just for your own records, and you understand what you did and why you did it. Document your acceptance or denial of the request for a reasonable accommodation, and the reasons why you're accepting or denying. Um, you also will want to document if you respond to a request with sort of a counter proposal. Here's an accommodation that we can do without it being an undue burden. We're offering this. Do that in writing so that they can then either accept or refuse your offered accommodation. If there is a dispute, if there is, a fair housing complaint or that sort of thing, then you'll have that documentation and you can justify your action either way. As part of the accommodation discussion, and a frequent one that comes across my desk often, is questions and issues about service animals versus emotional support animals, which are in fact two different things. It's not even just sort of a spectrum. Their service animals have a specific legal definition. They are specifically trained to do work or tasks that assist a person with a disability. Um, and once they have gone through that training and are certified as service animals, then they can legally accompany their human into public places like restaurants, stores, public transit, airplanes, libraries, etc. That is limited to service animals. Emotional support animals generally cannot do any of those things. Um, Under the legal definition of a service animal, it's currently limited only to service dogs and sometimes miniature horses. I don't know how they got that one addition to the category of dogs, but there it is. Um, a lot. So if there's any other animal that someone is bringing to you claiming that it's an accommodation, it is not a service animal. Um, Even if it does tasks that assist them with their disabilities, it doesn't meet the legal definition of a service animal if it's not a dog. I've yet to see in Davis, not that there haven't been any probably, but I've yet to see a miniature horse service animal request. It's just a matter of time, I'm sure. Um, and as I said, service animals are able to accompany their person everywhere because usually it's a task that the person needs sort of ongoing guidance, support, assistance with. So that can be, seeing eye dog or a dog that, triggers when someone is about to have an epileptic seizure. All those sorts of things are service animals. Emotional support animals is a much broader category. Any animal that provides comfort to a person with a disability. So not even necessarily assisting them with a task, bringing them their medication, reminding them, but just comfort and support to a person with a disability. Emotional support animals do not have those public access rights. So you can't bring your emotional support animal to the movie theater with you, but you can bring your service animal to the movie theater. They're generally restricted to pet-friendly spaces, so any place where a non-emotional support animal could go. California now has a specific process for ESA documentation. Um, in order to document the need for an emotional support animal, there's a certain list of providers, either medical or psychiatric or therapy providers who can provide the certification. They have to have an existing relationship with the individual and interact with them directly and discuss with them their disability and their need for the emotional support animal before they can provide that supporting letter of documentation. This was sort of an attempt to crack down on the perceived abuse, I'll say, before this of folks just finding a website online where somebody would email you a ESA letter that you could show to your landlord. Having never met you, having never talked to you before this. So that is now a process that has to be followed in order to, and there are specific things that have to go into the ESA documentation verifying that all of those conditions were met. So there is one way in which service animals and emotional support animals are treated the same, and that's for purposes of them being an accommodation for a disability. They're protected under the Fair Housing Act as reasonable accommodations, even in no pet properties. So if generally you have a policy of no pets, and someone comes to you with a service dog or an emotional support animal, generally, unless it's an undue burden, you would be required to accommodate that pet. Part of the accommodation is also that you cannot charge an additional pet deposit for a accommodation animal. You can still deduct for damages caused by that animal out of the regular security deposit, but you can't charge an additional pet deposit for emotional support animals or service animals. Still okay to charge an additional pet deposit for non emotional support or service animals. If you do that, just make sure that's written into the lease and that you document that separately. If you have a pet agreement or your lease says you're allowed to have one dog and three fish and whatever you're allowing, there would be an additional pet deposit of X dollars. If you do charge an additional pet deposit, that is counted against the total amount of security deposit that you can charge, which is now, for most purposes, limited to 1 month's rent. So if you're charging 1 month's rent of the security deposit and an additional pet deposit, that can put you over the allowable limit. So make sure that the combination of security deposit and pet deposit still isn't more than 1 month's rent. I usually advise people that because if you charge a separate pet deposit, you're only supposed to use that pet deposit to reimburse yourself for pet-related cleaning and repairs. Whereas if you just charge a regular security deposit, you can use it for anything, including pet repairs. So I think especially with the new cap of 1 month's rent, a lot of folks will start just charging 1 month's rent as a security deposit and not charging an additional pet deposit, just sort of folding that in. Another disability concern that comes up sometimes in especially long-term tenancies, but not always, hoarding issues. A lot of folks might not necessarily associate that with, well, what do I have to do and why do I have to accommodate that? If it's creating other issues for the property, for the health and safety of the people who live there. It is a recognized mental health condition under both federal and state law. Generally, the tenant cannot be evicted just for a hoarding situation. You have to discuss accommodations for that and engage in the interactive process. Those accommodations could include things like extended cleanup timeline. If there's a trash situation out in front, generally, say you give the tenant notice, you say, hey, I'm giving you 30 days to clean up your front porch. If there's a hoarding situation, you may be required to be more flexible on those timelines. Give them more time to complete the cleanup. Arrange for or providing professional cleaning services, allowing third parties like family members or sometimes adult protective services folks and that sort of thing to come in and work with the person to assist in cleanup. So again, because it's a reasonable accommodation and you're still concerned about and responsible for, health and safety issues, code compliance, all that sort of thing. Hoarding can still be grounds for termination if it creates a serious or immediate safety risk, like a fire hazard, structural issue, or a health code violation. Um, Animal hoarding is a thing. Somebody who's in a small unit with lots and lots of pets, more than you knew they had, for example, can create an issue. It's a penal code violation. It's a misdemeanor. Um, in general, in these sorts of situations, again, you want to make sure that you document what this condition truly is. If you get into a dispute about was it or was it not a serious enough uh, health and safety risk that justified you evicting the tenant, you better have evidence that you can use to show that. That may mean if you're worried that there's a health code violation or a water leak or a mold situation, you can give notice that you're going to enter so you can go inspect to see what's going on, and then document the situation uh, if if need be, so you have support for an eviction or other issues. If you're going to be making accommodations along the way, maybe you make accommodations and it still doesn't remediate the issue, and eventually you end up in a situation where you have to evict. But you got to make sure you've got that uh, backstory and the documentation if you need to stand up in front of a judge and explain why you did what you're doing. Illegal conduct on the premises. This, is pretty clean and dry. I mean, if there's something there, you either know about it or you hear about it, or you get a police report, or you're notified that there's a noise violation, that there's something else going on there. Your tenant, this also includes things like stalking, harassment, and domestic violence. All that sort of thing is all illegal conduct, of course, as well. Again, document, document, document. I think that's our theme for today. Um, if you and sometimes things have been going on that you don't learn of until later on. Um, if you find out about a situation, after on the second or third, incident, try to go back and fill in the gaps as best you can. Obviously, the tenants probably don't want you to know about what they're doing if they're doing this stuff. So, um, if there are police reports, whether they went out for a noise violation and they found some other situation going on, try to get copies of those reports. That can be tricky and take time sometimes, but try to be diligent in getting that. Again, so you have documentation to back up whatever you need to do to deal with the situation. Um, if you have specific procedures in your lease about, here's what the noise rules are, here's what the hours are, here's what happens if you get a first warning, second warning, and then here's what happens on the third one. Uh, Make sure you follow those as best you can, because that protects you from claims of selective enforcement or harassing conduct of them, or that whether they claim you're using it as an excuse to throw them out when they didn't really do what you are accusing them of, etc. So make sure you comply with, just follow your standard procedures as best you can. And it's not required to establish that someone's actually, arrested, prosecuted, and convicted of criminal activity in order to evict them for criminal activity. However, if you don't have a conviction, or if the DA decides not to prosecute, etc., and you still decide that it's serious enough in your mind that you want to evict them, be prepared for a judge or whatever that hears your eviction case asking about, well, they didn't even decide to prosecute them. How do you know that they really were dealing drugs or doing whatever you're accusing them of as the basis for your eviction. So make sure you have supporting documentation again before you head that way. One category of this sort of thing, as I said, is a domestic violence incident. It is illegal for you to evict someone for being a victim of domestic violence. It is, as you can imagine, not illegal for you to evict the perpetrator of the domestic violence. This can lead to difficult issues, though, because sometimes, the poor victim is there, and now they keep their home, but the person who was helping them pay rent is no longer there. And I'm sure they're relieved on one hand, but on the other hand, that's a financial hardship now on them, on top of everything else they've just had to go through. So, you can evict a perpetrator. You're not required to, depending on the situation. There may or may not be, restraining orders involved, that sort of thing. Down at the bottom here, it says, if there's a domestic violence incident and the victim gets a restraining order against the perpetrator that prohibits them from being, typically within 500 feet of the unit, then you should comply with that, acknowledge that. And the restraining order, however, does not terminate anybody's lease. Just the existence of a restraining order does not terminate the lease, doesn't relieve the person from their obligation to pay rent, even though they're not allowed to be on the premises based on the restraining order. Those things are, temporary orders. They may not be made longer term. The perpetrator has a right to contest that, and of course, contest their arrest or prosecution. The victim does have the right to terminate their lease without penalty if they give you written notice within 180 days of the incident. There are specific requirements, again, of what's supposed to be in their notice to you. They don't have to go into detail. They just have to notify you that they are a victim of domestic violence and that they are exercising their legal right to terminate their lease. They are responsible, once they do that, to pay up to 14 days of additional prorated rent. If they're not there for 14 days, they don't have to pay for the 14 days. But you can't charge them for any more than 14 days after they give notice. The other tenants may not terminate their lease. That again can leave you with potentially a roommate situation, or the victim has terminated their lease and left, but now the accused perpetrator is still there and owes you rent going forward. They are not relieved from their obligation to pay rent by the fact that the victim has terminated their lease and left. In terms of safety and security, a lot of these things are related to habitability, sort of the bare bones requirements that you have to meet. Operational deadbolt locks, not just locks, deadbolt locks on all exterior doors, and operable locking mechanisms on all windows. Those are the $3 things that you can get at the hardware store that go in the track and stop, or just a dowel that you lay in there that prevents people from opening the windows. All operable, all exterior windows are required to have those, at least at the beginning of the lease. And again, when you're turning the property, you better make sure that if the tenants took them out or broke the stick or whatever, that it's reinstalled and made an operable lock again. Adequate lighting and safety conditions in all common areas. That means, if there's a crack in the walkway or uneven driveway, that you get that fixed so it's reasonably safe. Maintain the habitability standards that we talked about. Change or rekey the locks always between tenants. And sometimes you may need to do that during a lease if you've got, a 5 roommates situation where 1 or 2 of them leave, and then you get new folks in. You still want to change the locks even during the lease term when you've got new tenants coming and going. And then you do have a duty to respond reasonably to a known criminal threat. And this is where the gray area comes in, because there can be disputes about whether or not you knew there was a threat, whether or not it was reasonable, the threat was reasonable, and whether or not what you did in response to that threat was reasonable. So beyond that duty to respond to a known criminal threat in a reasonable way, you're not under a just a general duty to provide safe, you know, safety or security measures, safe premises. A lot of leases often, remind the tenants, hey, you're primarily responsible for your own safety. Um, the tenant is, the landlord is not promising to provide any security measures, and if they do provide any security measures, then we're not guaranteeing that you can rely on them and be safe. Sometimes if you can get into a sort of a situation where you're almost punished in a way for if you provide camera or a alarm system or whatever, then the tenants can turn around and say, well, I thought it was going to be fine because there was a camera or there was an alarm, but it wasn't on that day, or it failed, and now you're responsible for whatever happened as a result of that. So it's almost a catch-22. Once you start providing, safety measures, then, it's important that you provide sort of disclaimers with that a safety measure you're providing is, assistance, but it's not a guarantee of safety. Um, so, as I said, the question is whether or not a specific sort of danger is foreseeable, or a criminal act is. Generally, criminal acts are not foreseeable in terms of, the theft or crime or that sort of thing, unless there's a specific history at that property, for example, or proximity to a certain, risk that you're aware of. If those sorts of things are there, then the landlord still does have a duty to take reasonable precautions. In terms of roommate situations, tenants and landlords have a duty to avoid nuisance situations, and they have to take reasonable steps to remedy them. That means the tenants have to reasonably work together. Um, in college towns, you have a lot of young adults who have maybe not necessarily, engaged in a lot of conflict resolution with folks that are different than them, that they haven't lived with before, or that they don't know well until they move in together. So you get called in sometimes to try to solve these issues for them. Adults have the same problem sometimes. Uh, but generally, there's not a duty to intervene or fix things for them if they can't get along, unless it reaches the level that it creates a health and safety issue, or there's actual, roommate on roommate crime, that sort of thing. Then obviously you have no choice but to get involved. It's difficult because in that case you have the same duty to both tenants, but you also have to make sure that you act reasonably to protect everybody, and protect everyone's rights. Um, because you own the same duty to all tenants, it can be tricky once you get involved. If you do have to get involved, again, document what your actions were, document the reasons for your actions, document the evidence that people give you that you're using to base your decisions on. If you can, you want to get a written acknowledgement or an agreement from all tenants as to what you decided to do to resolve the situation, so that you can kind of put the issue to bed and not have to resolve it again when it crops back up the next time. Included in roommate issues oftentimes are noise and nuisance complaints that can be from one roommate within a unit who is more studious, and one who is uh, creating issues that bother their roommates. It can be the person on the other side of the wall. It can be someone else across the apartment complex that is complaining about a noise issue, or somebody's following me back from the laundry room and I'm uncomfortable, and those sorts of things. So make sure that you have in your rules and regulations kind of as clear as you can for these sorts of situations, standards and procedures, how you're going to deal with noise and nuisance complaints. Follow those procedures. If your lease says you get 2 warnings and then we go to eviction, then if they've had 2 warnings and you get another complaint, you should ask them to leave. And if they don't leave, then you should initiate an eviction proceeding. If you don't do that for somebody who's got 8 noise warnings, then the next tenants who have 10 noise warnings are going to, have heard about those other folks and come back to you and say, well, why are you going after us, asking us to leave when you didn't ask them to leave? Uh, do the best you can. Sometimes you may or may not be on site. so it's hard to document and investigate what actually happened. But at least document what you were told and when you were told it, who told it to you. If there was a noise violation or the police come to break up a party, etc., try to get copies of those notices. Repeated or serious violations can be grounds for lease termination, especially if you have it listed in your lease as a reason for termination. Um, you do have a duty, though, to all tenants' rights to peaceful enjoyment of the property. So, if you get a repeated noise complaint from somebody next door to these other tenants, and you investigate it and you find that the noise that they are creating is not unreasonable, then they have a right as a tenant to listen to that music or make whatever noise that is, as long as it doesn't reach a level that infringes on the other person's right to peaceful enjoyment. That can be tough. Sometimes it calls in an apartment complex. Maybe you want to relocate one or the other of the two, so that they're not bothering anybody. But sometimes there's a time when you say, "Hey, I understand this bothers you, but this doesn't violate the noise ordinance of the city. It doesn't reach a level where I am able to do something about it. Why don't we, I can talk to them, you can talk to them, maybe you can figure something out." And we are at 1 o'clock, so I'm asking, hoping you can stay with me for a few more minutes. We are approaching the end here. As I said, there was a lot of material here. Subleasing and assignments. The difference between a sublease and assignment is an assignment is when the new tenant steps in for the entire remainder of the lease. We're taking over the whole apartment until August 31st, if it's a September 1st to August 31st year, versus a sublease would be more like, I'm subleasing my room for spring quarter. That's where the person takes in a portion of the space or a portion of the lease. That can be done sort of on a bedroom to bedroom basis, or that we're taking the whole place, but only for a month. And then it's going back to the original tenants, or they're subleasing to someone else. Um, Usually, unless they are released from the lease obligations, or there's some other basis in the lease for termination, the original tenant is also still liable for payment of rent. So if they sublease to someone and the person doesn't pay rent, the original tenant, the sublessor, can still be also responsible for that payment of rent. You can go after both of them. Uh, if you are going to prohibit subleasing or an assignment or limit it, then you need to specify that in writing in your lease agreement. If you want to prohibit subleasing or assignment without your consent, then you should state that in the lease. And certainly it's best practice in a multi-roommate situation, like an apartment or a large house where you got different people in multiple bedrooms, that sort of thing. That's not necessarily one family unit. You want to get everyone's consent, all the tenants, to a sublease or an assignment. That can be difficult sometimes. If 4 of the 5 people are okay with the new person coming in, and the fifth person doesn't want them to move in, that can complicate things. Okay, if in terms of sort of the catch-all here at the end, other property management issues, things that might come up during the term of your lease. One of the things you may want to do as an owner is get somebody to worry about all this stuff for you. That's a property management company, or in a larger complex, a resident property manager who lives on the property and is accessible, to the tenants, works in the office and that sort of thing. That can kind of run the day to day, manage maintenance issues and that sort of thing, and help you with that. Another thing you're required to do is register with the city that you have a rental property. That is done through the city's website, and payment of the annual fees for that rental registration. You're then on the city's registry of folks who are looking for housing. That's one good way to help them find you, among other things. Also, is make sure that you acknowledge that you're complying with all the requirements, like giving the tenants their notice of rights and responsibilities, their notification about how to use the waste cycling, sorting bins, etc. If you're responsible for maintaining habitability, as we talked about, making maintenance repairs as necessary, making sure that if there's a code compliance issue or one of the habitability systems fails, that you get things back set up as soon as possible. Dealing with ADA issues, responding to requests when they're made. And then an important thing that we didn't really talk about was having rules and regulations for your property, whether even if it's a single family home that you're renting out. It's best to have all that in writing. You can have it as part of the lease, or you can say, or you refer to in the lease, we've got rules and regulations for the property that we'll be giving to you at the same time as the lease, and you're expected to follow those as well. They will be changed. They can only be changed on 30 days notice and that sort of thing. So make sure you have those. If you don't, it doesn't have to be, like I said, it doesn't have to be War and Peace, but is smoking allowed? Where do you park? Where can't you park? Um, can you change your oil in your driveway or no? Um, can you put up a satellite dish? All those sorts of things need to be written down in advance so that everybody understands what the rules are and aren't. Um, so that is it for today, and this is our final of the 4 presentations. I want to thank the city for partnering with me to do this. We do have some time for questions. If and as I said, any of these topics probably would have been an hour into itself. So this is just a kind of an overview to give you aware of these situations. I'm hopeful that we can follow up on this and continue to work with the city to give you guys some more information and update all of this stuff, going forward. And certainly you're welcome to contact me. And there is a link here. And you can just search for the Rental Resources city webpage as well. That'll get you there pretty quickly. And it has a lot more resources for tenants, resources for owners, and some contact information as well for state and federal law and that sort of thing. So we'll take some questions if anyone has any they want to bring here. And as I said, otherwise, you're welcome to contact me offline following up this, and contact Patty and others at the city to get help.
I just want to say thank you. It was very informative.
Okay, thank you. Appreciate that. Okay, very good. Well, Patty, why don't you conclude the recording then? Thank you all again.